Thank you very much, Janine Jackson. I hope people watching this on C-SPAN or live stream will take some of her thoughts and apply it to the local media, which is more accessible. Obviously, local TV, radio, newspapers. Go down, see the editors, see the producers, talk to the reporters, rather than just withdraw and be disgruntled. My pleasure to introduce in the next segment on small claims court, Oliver Hall. He came to our attention when he was a law student at Boston College. He wrote a law review article on the obstruction to third-party candidates to get on the ballot and other obstacles. Somehow he thought that a two-party duopoly, excluding competition more vigorously than ever before in our history, by all these barriers, undermined the concept of a competitive democracy. So he came to Washington, and he became my lawyer, fighting ballot access restrictions and the main party's efforts to reduce competition to themselves by keeping third-party candidates off the ballot or harassing them, draining their resources, keeping them off the debates, and a whole variety of ways, confronting them with political bigotry and discrimination, for which there's no penalty, no criminal prosecution, keeping someone off the ballot with unethical means or harassing. And he was very, very persistent. He wrote beautiful briefs. Some of his petitions for certiorari to the Supreme Court were praised by very demanding attorneys. And he extended this persistence to his role as a consumer, and he got ripped off like everybody else gets ripped off, and he began to use small claims courts. And small claims courts are everywhere, as he will point out, but they're very unutilized by the people for whom they were established. They were established to help consumers. And most of the use of small claims courts are by loan sharks, payday loan people, installment loan rackets, landlords in poor areas, creditors. They use the small claims court. And he believes that millions of Americans should use the small claims court. They're very easy to use. You don't need a lawyer. Here's Oliver Hall.
Thank you, Ralph. I just have to say it was such an honor to represent Ralph all those years, and I only wish he was running for president again. I would like to say that now, especially when we have such a dearth of choices in this election and so much commentary about that issue. But as Ralph said, I'm founder of a nonprofit called Center for Competitive Democracy. We work to eliminate barriers to participation in the political process. So I guess Ralph gave some indication, but the question arises, what does that have to do with small claims court? Well, let me come back to that. I'd like to start with a story. The year is 1980, the place San Francisco, not the Tony area of San Francisco, not Russian Hill or Pacific Heights, but south of the city, near the airport. You may not know, San Francisco International Airport started as an airstrip in a former cow pasture a few miles south of the city. That was in 1927. But within a few short decades, they had jumbo jets flying in and out from Tokyo and London and Sydney, Australia. And the people there, who lived near that former cow pasture, found that the noise was somewhat irritating. As a matter of fact, it rattled their windows, shook their homes, woke them up at all hours of the night. Well, what would you do in that situation? What would you do? I mean, you basically can't live in your own house. Well, a woman named Gretchen Eisenberg went to small claims court. In September 1981, she filed a lawsuit against the city of San Francisco, which was the operator of the airport, and alleged a claim of nuisance and requested the jurisdictional limit, which was $750. Maybe the city didn't pay attention to that, but then her neighbor did the same thing, and another neighbor, and another neighbor, and another neighbor. By the end of the month, 170 separate small claims actions had been filed against the city of San Francisco by neighbors of the airport. And they all made the same claim, nuisance, and they all requested the jurisdictional limit, $750. And 116 of them won. Then they filed another 183 separate lawsuits in small claims court against the city of San Francisco. Well, that got the city's attention. And the city itself went into court, not small claims court, but into the local superior court, and requested a writ to actually enjoin the small claims court from adjudicating any more of these claims. And the superior court rejected that, and the Court of Appeals in California affirmed. It said this is a totally appropriate way to use small claims, and this is actually in keeping with the purpose of small claims court, which was to allow people to adjudicate claims that they might otherwise not be able to adjudicate because it's either too expensive, or maybe the money involved for each individual plaintiff is not sufficient to justify any lawyer for taking the case. And so they were free to keep suing the city of San Francisco, and that's what they did. They prepared a master complaint, they organized, they held workshops, they shared information and resources with each other, and they banded together to hire expert witnesses to testify on behalf of each plaintiff and to consult with lawyers. And they kept on going like that. Now, this is obviously a pretty unusual case, right? But not just because they filed so many different small claims actions relating to the same ongoing violation or harm, but because people just don't use small claims courts anymore. How many people here have filed an action in small claims court? Well, that's pretty good. Certainly less than half, but pretty good. But you know, small claims court is the original people's court. Before Judge Judy, before Judge Wapner, there were small claims courts. And they were founded in the early part of the 20th century. The idea originated with a Harvard Law dean named Roscoe Pound, who wrote an article that was very influential and essentially called for the creation of small claims courts, because there were all these claims that people have in their everyday lives, and obviously we still have them today, which don't rise to the level that you want to file an entire lawsuit and hire a lawyer, but they deserve to be adjudicated. People deserve to get justice, even if the harm is relatively small. And today, small claims courts exist in every state. The procedures vary somewhat, but they all share some basic characteristics. First of all, you don't need a lawyer. Anybody can file a small claims action. The costs are minimal, the procedures are simple, and adjudication of your claim is really lightning fast in terms of litigation time. The filing fees are very low. They range from $15 to about $150, depending on the state. And the maximum claim value ranges from $2,500 in Kentucky and Rhode Island to as much as $25,000 in Tennessee. So that's real money. It's worth your time. But what has happened with small claims courts? Some of us here today have used them, but the fact is that the original purpose of the small claims court has really fallen by the wayside, or at least it has been overshadowed. As early as 1972, an empirical study of small claims courts across the country characterized them as the forgotten court, because the idea of giving the little guy a chance to get his small claim adjudicated had really fallen by the wayside. Today, what you find is that the dockets of small claims courts are actually dominated by debt collectors, and businesses, and not by individuals seeking redress for the harms that they incur as a result of business practices. For example, a study of a California small claims court in 2002 found that 56% of the plaintiffs were corporate or business plaintiffs, while only 36% were individuals. So what you see is that small claims courts have been functionally hijacked by the very interests that they were intended to check. There was a story in the Boston Globe in 2006 that mentioned that the benefit of small claims courts is that they have these relaxed standards, but what's happened is that businesses have taken advantage of those relaxed standards to be able to go after small debts owed to them by individuals. Well, this brings me back to my original question. What does small claims court have to do with my work as what I like to consider myself as a civil rights attorney? Well, nothing directly, but it relates in this way. When we talk about breaking through power, litigating a case takes years, decades even. It's a very difficult thing to do. But small claims court is something that everyone in this room, everyone following along online, watching on TV, anyone can do it. And I'm living proof of that. I've won money judgments against corporations. I've collected them. One example, when I was still in law school, a store sold me a used computer as new. And it turned out to be a total lemon, and the thing just died after a little while. And they wouldn't even take a look at it unless I paid them another $100. And I said, I'm not going to pay you $100. This thing is broken. Well, I ended up having to sue them, and they ended up paying me more than I paid for that computer. And I went out and I bought a new computer. So the system works. And I would say that everybody can and should take advantage of this resource. It's something that is there that is just totally underutilized. Just to give you a few examples of the kinds of causes of action that you can take to small claims court. Well, really anything that you litigate in a normal court, you can also litigate in small claims court. So claims for nuisance or negligence, harassment, any of those types of claims. But then there are also particular statutes that provide a private cause of action for violations of the statute. One is the Telephone Consumer Protection Act. Has anyone been harassed by a telemarketer lately? I mean, I'm on the do not call list. I get calls all the time. Well, this statute provides for $500 per violation or actual damages, whichever's higher. And for knowing violations, you can get triple damages. That would be $1,500. So think about that next time you get a call from a telemarketer. Look at your caller ID and think about whether you want to take action. Another one is the Fair Debt Collections Practices Act. Also provides a private right of action for harassment by debt collectors, and you can get damages and attorney's fees under that statute. The one that I tend to focus on is the Consumer Protection Act that each state has enacted. Each of these states has a consumer protection statute. It allows anybody to sue a corporation for violations of the statute. Here in DC, the statute provides for $1,500 per violation or actual damages, whichever is greater, and then it also allows for attorney's fees. I've sued under that statute and I've won, so it's something you can do. And that brings me to, I guess, what I would like to wrap up with, which is, we come to events like this and we're presented with so much useful information, but oftentimes we feel like it's maybe in the level of abstraction or the problems are too big, we don't really know how to attack them. Well, here's something specific you can do. Everybody, when you go home today or if you're watching online or on TV, Google your state's consumer protection statute. Familiarize yourself with the procedures, and importantly, look at what the remedies are. Look at what you can win if you avail yourself of this resource. And then the next time that Verizon or Comcast or Bank of America, one of these corporations that we all deal with on a daily basis, hits you with a bogus late fee and they refuse to remove it from your account, or any of the other number of abuses that we have all encountered, think about taking them to small claims court. You can do it, and I tell you, it feels pretty good to make them pay you in that circumstance. I wanted to just return to Gretchen Eisenberg to wrap this up. The woman who first sued the San Francisco airport. If you go to Wikipedia now and you read the entry about the San Francisco airport, it boasts that it was one of the first airports to implement a fly quiet program, which grades airlines on their noise when they fly in and out of the airport. And not only that, but it was one of the first airports to conduct a residential sound abatement program, a retrofitting program. And it turns out the San Francisco airport to date has spent $153 million and has insulated some 15,000 nearby homes. And if Wikipedia is to be believed, and I'm not sure this part is to be believed, but it was a very successful effort. But anyway, the point is, they put in the effort. And this took place sometime in the early 1980s. So by my calculation, that was right around the time Ms. Eisenberg and her neighbors filed their 353rd small claims action against the airport. And that's what we call the large potential of small claims courts. Thanks very much.